Welcome and welcome back to Employment Law Show. If you've caught our other shows, it's good to have you back. Exciting show today, Lior. Lots of stuff to cover, including five things you need to know return to work for employees. That is coming up in just a bit. We'll get to some emails. We'll get to some phone calls from our long-running radio show as well. And we'll refer to pocketemploymentlawyer.ca. I would imagine throughout the show, you can go there anytime, by the way, absolutely free, anonymous, and a ton of employment law information. So let's get started, pal. Week that was, what do we got happening this week?
Man, would you be surprised, John, if I told you that I've been answering a lot of employment law questions? Would that shock you?
Never. Hasn't for 8 years. Why would it now?
My gosh, it really is a tremendously busy time, which I very much enjoy because I get to hopefully ease people's concerns and tell people what they need to know about those workplace problems that are bothering them. And that's why I am so happy to have this platform where we get to go on TV and tell people what they need to know. This is the time. There's no other show like this anywhere in Canada. So it's great that you have an opportunity to learn about employment law. Maybe now with COVID-19, you've lost your job and you want to know what that means or what you're owed, and could you have even lost your job? Maybe you're in a situation right now where your job has changed and your hours have been reduced or your pay was cut. Can that happen? Spoiler alert, it can't. We'll talk about that more. Or maybe you're on a temporary layoff and you want to know how long that can last. Whatever that issue, we'll try to cover it on this show, on every show. You can watch more of our shows online, or you can reach me in the office. Always to talk to me personally, privately, email, phone numbers. We'll give you that contact information throughout the show. Well, I always like to start off with the week that was, a situation that I've dealt with just over the past few days. I mentioned temporary layoffs. This is a classic example of that. I spoke with a lady who had been on a layoff since April 2020 because of COVID-19. Now her company, in fairness, was struggling with COVID-19 like many companies, and they had to make some cuts. You know, business was obviously not as good, and operations were impacted. And she hasn't yet been back to work. She contacted her employer and she asked, well, when can I come back to work? Do you know how long you're going to keep me on this layoff? And they said, no, unfortunately, we don't. We don't know how long. Hopefully, we'll bring you back at some point over the summer or the fall, but we do not know. Now, she, like many of us, has to put food on the table, has to, at some point, go back to earning what she used to. So she called me, and she wanted to know, well, Lior, what do I do now? Do I wait indefinitely, or is there a second option? Well, John, hopefully our regular viewers know what I'm about to say. Yes, there is a second option if you're on a temporary layoff, COVID-19 or not. You can treat that as a termination of your employment. You can choose to say, I am not going to wait. I am not going to pretend like this is okay. I'm going to choose to treat that as a termination. I'm going to get my full severance. You can do that. Remember, severance is as much as 24 months' pay. COVID has not changed that. In fact, we recently had a court decision confirming this, confirming what I've been saying for the last year plus, that despite COVID-19, despite the impact of the pandemic, an employee that's been put on a temporary layoff is constructively dismissed. They can choose to treat that as a termination of employment. So that's what I said to this lady that contacted me. That's what I'm saying to you right now. If you're on a temporary layoff, yes, you can wait. And I don't know how long you'll be waiting. It could be a long, long time still. Yeah. Or the second option, you can choose to treat that as a termination. Get your severance right now. If that's what you want to do, please give me a call. Let's have a talk about it.
Now, for the thousands of people that now may be considering this just based on what you said, that whole, we'll say it's a year for sake of argument, that whole year they've been off because of COVID-19, is that year also tacked on to their severance? So now a 12-year employee who's been off for a year is now considered a 13-year employee? Does that add into their severance package?
Well, we would take the position that the termination happened back when they were laid off. So if someone was laid off in April 2020, even though right now we're in 2021, that termination happened back then, so that year would not count, but that's okay. They still are going to be owed their full severance. And remember, severance is as much as 24 months pay. So when we're talking about severance, it's not this silly nonsense of a week per year of service. It's not that. It's not even close to being that. It's a heck of a lot more than that. Pocketemploymentlawyer.ca, by the way, to find out how much actual severance you're owed.
And employmentlawyer.ca, throw another website at you, is where you will go to catch a radio show near you, which we've been doing for 8+ years, several times a week. We get some of the great phone calls on the show. Got to thank everybody who tunes into that every week and contributes to the show as well. Want to get to our first phone call from our radio show right now, Lior.
I work for a trucking company. They sign contracts with different companies in order to haul their freight. I've been there for 24 years. The contract that I did sign at the very bottom said that due to the work, layoffs are possible. So if they do lay me off because they didn't get another contract with the company, do they still owe me the severance? It would be a permanent, because if they do not get the next contract with the company, it would definitely be permanent.
Yeah, so obviously we want to see what the contract actually says, because in some situations, your employer may have you sign a document when you started working that gives them the right and the power to put you on a temporary layoff. So if you sign something like that, yes, your employer may be able to do that. But something tells me that this person, like many other truckers, is being quote unquote misclassified as an independent contractor. I see that often with truckers. So chances are, if you're a trucker, you're watching us right now, despite what you may have signed, despite what you believe that you're an owner, operator, you are an employee. And if you are an employee in the eyes of the law, you're owed your severance if you are let go. And the same severance as everyone else. So let's take this information, the person that just contacted us, that caller from our radio show that we listened to, and let's plug their information into pocketemploymentlawyer.ca, our severance calculator, so that we can see how much they're actually owed. So a truck driver, 61 years old, been there for 24 years. His employer is saying, no, you're not going to be owed any severance. Well, you can see right at the bottom of the screen there, he's owed anywhere from 20 to 24 months of pay. 20 to 24 months. That's a lot of severance that they're owed. So remember, truck drivers, even though you believe you're an independent contractor, you're almost assured to be an employee in the eyes of the law. If you lost your job, severance is owed, and you have to give me a call.
Quite often we hear from truck drivers, and it's like, yeah, I drive truck or I haul freight for several different people, so I guess I'm an independent contractor. But, a person over here is responsible for 70% of my income or 80%. Does that change the dynamic at all?
So in that situation, so if you're a driver and you drive for a number of entities, but there's that one that gives you the bulk of your work, well, you're going to be considered what we call a dependent contractor, not an independent contractor, but a dependent contractor. What that means is if you are a dependent contractor and the company that gives you the majority of your work, if they let you go, they have to pay you severance as if you were an employee. So again, potentially as much as 24 months pay. So not only may you be misclassified and you're really an employee, even if you are a contractor, you may still be owed severance if you lost your job. So by all means, please do the right thing, do the smart thing and the responsible thing. If you lost your job, whatever the circumstances, give me a call. You may and probably will be surprised by how much you're legally owed.
Any other questions while we're not doing the show or a radio show? Terminationquestions.com. You can go there anytime, ask your questions. A member of Lior's team will get to it quickly and give you a full and complete answer. First one is Sarah today. Lior says, I've been asked to sign an employment contract as part of a job with a new company. What are some of the most important things I should look for in that employment agreement?
Very important question, and very smart to ask that question before you sign that agreement. That the employment agreement, probably one of the smartest or one of the most important documents you're going to be signing ever. All right. So you can't just look at what your salary is or how many weeks vacation you're getting. Obviously, you're going to look at those. Everyone would, of course, but there's other things. Let me give you some examples. Number one is there a term in there that allows the company to change your job or change your pay? So think about it. You were so eager to negotiate your salary of $75,000, but you've also agreed that the company can change your compensation at any time. So what's the point of even agreeing? So is there something that allows the company to change your job, change your hours, change your pay? Look out for that. Is there something in that agreement that prevents you from working if you lost your job? A non-competition obligation, for example. Probably even more important, is there a term limiting your future severance? Employers are starting to use these terms in employment agreement. We call them termination clauses. They try to limit your future severance. And the problem is if you sign that and at some point down the road you are let go, by signing that term, you may be losing tens of thousands of dollars in severance, maybe even hundreds of thousands of dollars. The difference could be massive. So you want to watch out. You're worried about whether the salary is 70 or 75, but you may already be agreeing to be walking away from six figures in future severance. Now, the good news is, John, that these terms can be negotiated. I'm not just telling you what they are to scare you. You actually can negotiate them. Identifying them and talking to your employer and trying to negotiate is quite possible. I help employees do that all the time. If you want my thoughts as to how to negotiate the terms of employment so that you don't give up your rights, give me a call.
Coming up shortly, common questions about returning to work. But first, we'll take a short break. In the meantime, 1-855-821-5900 and terminationquestions.com. You can use that as well anytime. Stick around, lots more coming up. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. Welcome back. Employment Law Show, a very busy and topical topic, if you will, Lior, and that is coming back to work and questions about that, returning to work. This has never been more important than last year with COVID-19 because a lot of people have been off for some time and now they're being brought back into the fold of being back in the workplace, and there's some things they should be aware of, right?
We've never had, I don't think, so many people off work for the same period of time as we've had over the last year. So that also means that we've already started seeing people coming back to work, a lot more than we've had before. So you need to understand, if you are called back to work after COVID-19, your employer is opening back up, hopefully, with vaccines, COVID-19 is getting better. What does that mean to your rights? And that's what we're going to try to talk about right now. How do you deal with any situations where you're coming back to work, but it's not exactly the way it used to be? That's what we're going to cover.
First one, what if my employee does and can they bring me back to a different job when I return to work?
Probably the most common and first question that I get is, I'm going to go back to work, but do they have to give me back the same job? Well, the answer to that, it depends. So an employer can make some minor changes. So for example, if you used to operate machine A and now you're going to be operating machine B, well, that's probably something your employer can do. It's not considered a significant change. But if the job they want to bring you back to is a job that is a lower job, it's a demotion, or a more physically demanding job, or a job that's going to be a lot more difficult and less favorable, then that's a big deal. And that's not something an employer is allowed to do. By changing your job in a significant way, it can absolutely be a constructive dismissal. So yes, some minor changes can happen. It doesn't have to be the identical exact job you had on the day you went off. But once we're beyond a similar job and becomes a significantly different job, that's constructive dismissal. Now, every situation is different. So if you're in that position, you're going back to work and it's a different job, but you don't know if that change is significant enough, call me. Let's talk about that. I'm going to ask you some questions and I'll be able to tell you, is that something that's allowed or not? So some flexibility is okay. A lot of changes, significant changes, not okay.
Number two, can my employer lower my pay?
That's an easy one. And the answer is no. You have to be brought back to the same pay. And if you're not, if you're going to face a pay cut, that could be a constructive dismissal. Absolutely. Now, here too, there's some flexibility. So, if instead of 60,000, you're going to go down to 58, not going to make you happy, but probably something an employer can squeeze by and get away with. but they certainly couldn't reduce you from 60 to 50,000, not even close. So if you are facing a significant pay cut, not allowed, you can absolutely treat that as a constructive dismissal. And I want to give you a word of caution here is that if you're going to want to be that good soldier, like many of us want to be, and say, well, I'm going to take one for the team and I'm going to take this pay cut to help my employer, as nice and as admirable as that is, the problem in doing that is that you've now given the company the right to do it again. You may have thought you're only doing it this one time to help the employer, so I'm going to take this pay cut and be that good employee. Now your employer may be able to do it again and again and again because you let it happen that first time. So you have to think about yourself. You have to think about employment law rights that you have. If you don't, you could be giving up a lot more than you realize.
What if it's not, something as simple as, I get paid every 2 weeks, they've dropped it a percentage, blah, blah, blah. What if you're on a commission basis? Can they change that structure when you come back or no?
Well, if it reduces your compensation, the answer is no. Any way you slice it, if you're making less money, then the answer is the employer cannot do that. Now, if they take something from column A, but they add something from column B, and it kind of all evens out at the end of the day, that's okay. Yeah. It's not going to impact you. But if they change the commission structure, they increase the targets, or they change the margins, and now because of that, you're making less income, less money than what you did before, well, now we're back to constructive dismissal. It's not something an employer is allowed to do. So once it starts impacting you financially, you have to think constructive dismissal, and the same warning applies. If you let it happen this one time, you may give the company the right to do it again and again and again. So be very, very, very careful.
We're talking about a short list, but there's so many more you could talk about. Changes that could affect you returning to work. Now, this one quite possibly could be the biggest one on the list. And can I choose to work from home? Some people don't like it, and they want the workplace to open up again and get back into the office. But so many people are loving working from home. Can they keep doing it?
I'm one of them, by the way. I do enjoy working from home, and yeah. I have a lot of friends and colleagues that love it as well. But not everyone does. But either way, the question that comes up so often now is, well, once I'm back, once we don't have this word COVID in our vocabulary, do I have to go back to work, or can I say, well, I've been working from home for all this time, can I just stay home? Well, generally the answer is no, you cannot choose to continue working from home. Your employer is allowed to say that now that COVID is over, once COVID is over, we can go back to the way things were before COVID. We can go back to that old status quo. So if before COVID, your job was in the office, but during COVID, because of COVID, you've been working from home, your employer can say, now we need you back in the office full time. And you cannot say, well, too bad, I'm not doing that. If you decide to do that unilaterally, that could be considered a resignation. The better thing to do is to talk to your employer and try to, if you can work out some arrangement that everyone can live with. Maybe you work sometimes from home, or some days, or some weeks. Oftentimes an employer is going to be flexible, but the employer is able to insist that you go back to a pre-COVID work arrangement once that's possible.
What if I'm not called back at all?
Well, that's one thing to remember, is that your employer does not have to call you back, in the sense that an employer can choose to end the relationship with you, right. But, and this is the important one, they have to pay you your severance. So if you're not going back to work, you can choose, forget about choosing. Your employer has to pay your severance in that situation. They have no choice. There's no way to say, we're not calling you back to work and we're not paying you severance. Impossible. Cannot happen ever. But it goes beyond that. That's what I started saying, is that even if your employer is planning on bringing you back to work, but right now you're still on that layoff, you can choose, the employee can choose to treat that as a termination and say, I am not going back to work. I'm going to treat my layoff as a termination and make you pay me my severance. So that's a decision that you as an employee can make. We talked about that at the beginning of the show. So if you are in that situation, if you're tired of waiting, if you don't know when you're going to go back to work, and you just want your severance now so you can move on, let's talk about it. Give me a call. It's not a complicated process. The law is very clear that you can do that. So let's discuss it.
Okay, I'll get to one more of these, and we'll finish again with a big one that's going to be becoming more and more popular as time goes on. Is that, can my employer either require me or force me to get a vaccination before I return to work?
Probably over the past 60 days or so, this has been the main question I've been asked. I've been asked this by employees, by employers. I've been asked this in the media. And here's my answer. for most people, your employer cannot require or make you get a vaccine. Now, there may be very limited circumstances if you're working in a long-term care facility or in a hospital where the risk is so significant that the employer may say, well, I have to protect everyone, I have to do this, I'm going to say that you get a vaccine. But that's going to be the exception. For most individuals, your employer cannot make you get a shot, cannot make you get a vaccine. You cannot be punished, fired, threatened. Nothing can happen to you if you don't. It's a personal decision. It's a decision that people have to make for themselves, and your employer cannot make you.
Before we take a break, let's get to one more phone call from our radio show, Lior.
I was hired by a company to go and work different places around the province. I had an episode where I collapsed because of a now diagnosed level of diabetes 1. And I spent 6 weeks in hospital. One of the young fellows that I hired, I was asked by my employer to start training him up to be a construction superintendent. He took over my position. I offered my services to my employer. My employer said, well, I've not been allowed to come back to work.
Wow.
Well, you know, sometimes when it comes to construction, this person mentioned he's a construction superintendent. It could be the Wild West when it comes to employment laws, but it shouldn't be, and it really doesn't need to be. Why? Because employment laws apply in construction as well. So let's be very clear how this works. If this person is now cleared medically to go back to work, his employer has to make all efforts to try to bring him back. They can't avoid it. They can't ignore him. They can't decide that he's not fit. That's up to his doctor to say. And if he's cleared to return to work by his doctor, if he has that doctor's note saying he can go back to work, whether it's full-time hours or part-time, his employer has to make all efforts to take him back. And if they don't, that's not just a wrongful dismissal. That's easy. But it's also a human rights violation. If you can come back to work and your employer won't let you, if you have that doctor's note saying you're ready to go back to work, your employer's not telling you if they have a job, they're not getting back to you, they refuse, they say you have to wait. If any of that happens, we need to talk about it. That's illegal. The employer has to take you back to work. Now, if they cannot, they tried, they looked, there's no jobs available, a lot of things have changed in the meantime, then and maybe only then can they not bring you back. They still have to pay you severance, of course, but in that situation, it may not be a human rights violation. If you're not going back to work, your employer's not cooperating, get on the phone and give me a call.
We have lots more to share, but we'll take a short break first. And that phone number, 1-855-821-5900 to reach out through email, help@employmentlawyer.ca. It's the Employment Law Show, and we're coming right back with more. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. And welcome back. Yeah, employmentlawyer.ca. That is the website as well. And many things about employment law, but also links to our long-running radio show. We'll get to phone call number 3, Lior, from our radio shows.
My boss, he changed the terms of my contract. I was only able to work 4 days a week because of medical reasons, and that was what it was in our employee contract. Then it said, well, you can't work 5 days a week, and I need you for 5 days, and I'm terminating you. I worked there just a little over 10 months. I'm just wondering what sort of severance I'm entitled to.
So what kind of a job then how do you?
I'm 53, and it's in the construction industry. I worked at the office, like it was administrative.
So the employer is allowed to say, by the way, John, that well, we now need you 5 days a week. And if you're not, then we're going to let you go. Why can the employer do this? Because an employer can let someone go at any time and for any reason. The fact that she refused to go to 5 days from 4 days is not a form of misconduct. She had every right to say, I'm happy at 4 days. I'm not going to go to work 5 days. But the employer is allowed to let her go without cause. Going back to the usual principle, your employer can let you go as long as severance is paid. So for her, the issue is that of severance. Now, the interesting thing is here, she's been there for 10 months. Well, a lot of people would think, well, she's been there less than a year. Maybe she gets a week's pay. If she hits it out of the park, she gets 2 weeks' pay. Nonsense, not even close. Short service employees, this is 10 months of short service, are actually owed significantly more than you realize. So let me show you how much she's owed. Let's go to pocketemploymentlawyer.ca and let's plug her information into our severance calculator tool. So she's been let go because she can't work 5 days. That's okay. Her employer's allowed to let her go, but severance is paid. She's 53, an administrative role, 10 months of employment. She is owed easily 3 months' pay. You see that on the screen. Now, even that, John, is conservative. It could be 4 or even 5 months' pay, but certainly 3 months is a no-brainer for her to get, even though she only worked there for 10 months. So think about it. You may have only worked for a company for a few months. You were let go. The fact that you were let go may not be wrong. It may not be illegal. But if you did not get the severance that you're owed, which could be several months' pay, that still makes it a wrongful dismissal. So short service or long service, if you lost your job, you have significant entitlements, you have to give me a call if you lose that job.
All right, one more time, Lior, let's go to terminationquestions.com and get a question. This time it's from Stuart. Stuart says, can my employer force me to respond to work outside my normal hours?
That's a great question, and the answer is no. And why? It's no because he used that term normal hours, meaning he has his regular set hours. So whether those hours were set initially when he started working in an employment agreement, or maybe they were simply set by virtue of that those were the hours that he worked. They were set by virtue of him working certain hours. His employer cannot change those hours and cannot expect him that now he's going to work different hours, be on call or available in different hours. For the employer to have done that, they would have had to put that in the employment agreement. So employee, your hours of work are 9 to 5, but we may need you to respond to work calls outside of those hours. If that employment agreement said it, then that would have been fine. The employer cannot come up with that after the fact. He can absolutely say no. Now, can his employer let him go? Remember what I said before. Yes, they can, because they can let him go pretty much for any reason, but severance has to be paid. That's not a form of misconduct. That cannot be used as a termination for cause. That would be a termination without cause, meaning full severance must be paid and must be paid right away.
Now, if this employee's been doing this for a year, 2 years, and now he has a beef about it, can the employer say, well, now it's an implied term of your contract because you accepted it?
Absolutely. Yes. If you are doing something that you didn't have to do, you work extra hours, you work on weekends, things you didn't have to do, but now you say, well, I don't want to do this anymore. Now that's a problem because you've done it. It became a term of employment. So if you don't want to open a door wide open, opening it a crack could be very problematic. So be very careful. Tell your employer, I'm only going to agree to this for a certain period of time. After that, I'm not agreeing to it anymore. Otherwise, you may find yourself in a very difficult situation.
Again, questions like that, terminationquestions.com, that is where we got it, but there's other avenues as well, 1-855-821-5900 and help@employmentlawyer.ca. Hope you enjoyed the show. Reach out, don't hesitate, and get educated. We'll catch you next time on the Employment Law Show.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca.